Good evening, everybody. Welcome to the Planning Commission meeting for July 7th, 2020. The time is now 7:02, and I'd like to call the meeting to order. Let's start off with roll call. I'm going to just read off everyone's name. If you could just say here. I know you're here, but just for the record. Michelle Williams.
Here.
Hi.
Hi.
Tom Fitting is not present, so Tom's not here. Rich Gordon.
Here.
Hi, Rich.
How you doing?
Good. How are you? Nicole Davidson.
Here.
Hi, Nicole.
Hi.
Mary Salvatore, not here, and I am Kirk Scott, and I'm here. Mr. Bombach is not going to join us tonight, and Elizabeth Allen is no. Okay, so we have a quorum, so we can just go with where we are with the members that are present. So we're going to skip the Pledge of Allegiance, and we're going to jump right into staff. Mr. Gaishel, do you have anything to report?
Actually, do you have any call for public delegations?
Oh, yeah. Sorry.
No worries.
Yeah. Yes, this is our first Zoom meeting that, so it's going to
First
be.
meeting in 4 months. So no problem.
Yeah. Okay. So, all right. So public delegations. Public delegations is time for the public, where they are invited to speak to the commission about certain matters, referrals, or applications. I'm sorry. Items, referrals, or applications subject to decision by the commission or a public hearing or litigation may not be discussed. During the delegations, the members of the commission cannot answer questions directly or make comment. Do we have any members of the public wishing to speak at public delegations?
Unmute Mr. Hooper. Mr. Hooper.
For the record, Mr. Hooper, could you please state your name and your address?
Well, I'm trying to unmute him, so if he could say, or if he could raise his hand if he wanted to speak, or type in the chat box. For whatever reason, I can't seem to unmute him. Okay. Not letting me unmute.
I wonder if he could override you.
Gary,
When you click to unmute, he has to approve it.
Yes, sir. Okay. So I would say not hearing from Mr. Hooper. The only other member of the public is Mr. Garrity, but I know he's here for items unless he has some other matters he wants to discuss.
I think he has to unmute it himself at this point. Other than that, yeah.
So hearing none, Kirk, I think it would be okay to move on.
Okay. All right. So that brings us to communications. Mr. Gaishel, do we have any communications?
I don't have any at this time. Nothing specific.
Okay. And the zoning representative kind of lost track of the zoning meetings. Have they been going on as scheduled with the Zoom?
So the zoning meetings have not resumed. I believe they're trying to wait for the ability to hold a public meeting in a public forum in the town hall. So
okay, so that ties that up. No zoning representative report, which brings us to Mr. Salerno as ex officio. Do you have anything that you'd like to share?
Sure. Welcome to Zoom. We've had a lot of meetings on the Board of Selectmen with Zoom so far. So just quick note, Town Hall opened officially this week. So it is open to the public. So if people want to pay taxes, you have to wear a mask and stuff. This is the first week it's open. You'll probably, as of right now, there's no plans to have meetings in the town hall I think the governor just put the brakes on the next stage. So for now, plan on Zoom. And then let's see, the new year at the town hall, town budget just started July 1st, so our budgets are all anew. The Board of Selectmen unanimously passed moving forward on the public safety building for the additional costs to complete. That's going to the Board of Finance for a decision, and then if they approve, that will go to referendum. That's all I have for right now. Hope everyone's having a nice COVID-free summer.
You also, thank you very much.
Thanks.
Okay. Mr. Gaishel, do you have anything?
Not specifically. I think, as you know, due to COVID-19, we received a 90-day extension on all applications pending before the commission and on any of those that were submitted during this time. I believe that will be applicable to anything that gets submitted up to September 20th. I got to look back at the date. I forget the date that's in place for the state to end the emergency, I guess. So when things run out, we'll be back to the regular schedule with applications and their receipt and process. So that's really the big change that's occurred. So we do have a few items that were lingering left over from February that are on this agenda tonight, and hopefully we can clean those up.
That brings us to subcommittees, which walkability, Mr. Fimister is not currently a board committee member. Mr. Gaishel, do you have anything you would like to add about walkability?
So in regards to that, Don had completed a significant amount of work on that study as far as where we can make new sidewalk connections. So I'm going to take that information, apply it to the transportation piece in the POCD. I guess just as a way of background, Kirk has asked me to give him a hand with drafting that due to some time constraints. So we're going to be incorporating that, and I picked that up, and hopefully by the week's end, we'll have a finalized transportation section and a few others as well. So things are moving forward. So really, in terms of the walkability study, I don't know that we need to have a subcommittee of anyone anymore. I think at this point, the Planning Commission can pick up the ball with what the work that isn't done and make some decisions of policy, regarding policy and walkability in that regard.
Okay. Thank you. And that brings us to the POCD update 2020. Michelle, would you like to start with that?
Yeah, sure. So looking back at our minutes, it looks like we haven't met since the public forum happened on January 29th. But just for the members and people on the line who aren't on the subcommittee and didn't get the update there, we had a very good public forum at the end of January that was well attended, where we got a lot of really detailed and thorough feedback from various members of the public on what themes or specific ideas they'd like to see incorporated in the 2020 Plan of Conservation and Development. We have been hard at work now, back meeting after COVID to finish up the plan, and we anticipate sending it to the Board of Selectmen for their review in August. So lots of work going on behind the scenes on that now with the subcommittee. I believe this commission will receive the document at the same time. Not our initial goal, but as you know, COVID threw everything off for everyone. So we're working with what we've got, and we actually feel like we're in a pretty good place as far as making the needed updates to complete the document.
Thank you, Michelle.
If I can add, I don't know if Michelle mentioned, I didn't hear just so you know, that 90-day extension that applies to applications does not apply to the POCD, and thus we're under a bit more of a time constraint there. Just so that the public understands that we were not awarded a 90-day extension on submitting the POCD.
Right. Okay, so subdivision regulations, we're gonna push that discussion until after the POCD, or what do you think we should do with that?
Yeah, I mean, that's fine. My suggestion is maybe consider putting a subcommittee together, you know, again, depending on the depth of review that you want and what you really want to look at. I mean, we can just kick it to the next meeting. We have, if you'd like.
I think it's a good idea to keep it on the agenda, and we could continue to push it. I just wanted to stay in the forefront of everybody's mind that we do have some work coming up with that, and hopefully as time goes on, people get some ideas of what they think should happen with that. Let's see, which comes to my section. I'd like to thank everybody who's been involved with the POCD revisions. Everybody's been doing a really good job, working really hard. We had a hiatus there, but I think we have a good plan for getting back on track with that. So thank you everybody for that. And I guess I probably should have mentioned the rules for doing the Zoom meeting. Gary, do you think you could, in a nutshell, tell us like the protocol for like making motions and like, you know, you're supposed to say your name when you make a comment and, you know, things like that, just like the etiquette for doing a Zoom meeting in a professional, just for the benefit of one, myself and anyone else on the commission that doesn't have a lot of Zoom experience. If you could, really quick, if you don't mind.
Yeah, sure. I would just want to keep in mind that we do have folks that are on the meeting who don't have their cameras showing, right? So whether they may or may not be able to see you. So it's nice if you're making a motion just to state your name as the member with the motion. We'll make sure that Sue picks that up for the minutes because we do have to record the minutes. Let's see here. During each agenda item, only the board, staff, and presenters will be unmuted to speak on that particular item. If in the event of a public hearing, only one person is allowed to speak at a time. So if they want to speak, they have to raise their hand. There's a little tool that they can click on to raise their hand and indicate that they want to speak. Fortunately, tonight we don't have any public hearings. The only person we'll be hearing from is Mr. Garrity. And for members and alternates for all motions, in the interest of making sure we have the clear record, again, just roll call, speak your name. And the only people who are allowed to share their screens will be the hosts. So as a way of background, all the information that's discussed at this meeting has to be posted on the town's website 24 hours in advance of the meeting. And while you know, in the events of public hearings, things can get submitted during meetings. So that's another, we have to handle that. It's interesting. But that said, all of those materials that are going to be discussed tonight are available, one, on the website. I do have them readily available to share my screen with the commission should you want to look at any one of those. If we haven't had past practice where we share the screen and let the applicants share their screen, we haven't had to do that. They've been able to provide all the information digitally to the town, so we can do that for you. Let's see. Again, the whole meeting is recorded from start to finish. It will be posted on the town's website at some time tomorrow.
All right. Thank you, Mr. Gaishel. I appreciate the clarification. That was very helpful. Okay, so which brings us to acceptance of the meeting minutes. Do I hear a motion to approve the meeting minutes from, let's see, January 7th, 2020?
This is Michelle Williams, and I move to approve the minutes of January 7th.
This is Rich Gordon. I second.
Is there any discussion? Okay, without any discussion, all in favor? I'm gonna do a roll call here to, as we just discussed for the vote. Michelle,
Aye.
Rich,
Aye.
Nicole,
Aye.
and that's myself, aye. So let the record show that the meeting minutes from January 7th, 2020 are approved. Which brings us to public hearings, which there are none. Subdivisions and re-subdivisions are none. Zoning referrals, none. And municipal referrals are none. We have no old business. And we have 2 items that are new business. Mr. Gaishel, would you like to discuss these?
Sure. We received an application from Kristen T. Clark, PE for English Harbor Asset Management LLC. She's the owner, an application for a 4-lot re-subdivision of approximately 3.8 acres of land zoned RU40 located at 22 and 24 Upper Kensington Drive in East Lyme. The assessor's map is lot 40, lot 22 and 23. We're slated to schedule a public hearing. Ideally, we'd like to have one at the end of the month on July 27th. Matter. The other application that we received that also requires a public hearing and would like to do it on the same night is item C. It's the application of Jason Rosalia, Fast Construction LLC owner, application waiver request from section 22.5B of the East Lyme zoning regulations for a 1-lot re-subdivision of 5.29 acres of land within the R40 zoning district located at 24 Darrows Ridge Road, East Lyme, Assessor's Map 44, Lot 8-31. That also needs a public hearing. So I would just take the commission's direction here to go ahead and schedule that if there's any.
Do we need a motion for that?
No.
Okay, so yes, are the commission members able to attend in July? It would be the last week of July.
Gary, this is Michelle. Can you just say that exact date again, the 27th?
Yes, July 27th.
Thank you.
Should be a Monday.
Great.
Monday.
A Monday.
Let me just check here.
I for sure can be there.
Rather be before the POCD meeting? Is that what POCD meeting?
I believe our POCD meeting, it would have to be before that, obviously.
Before that, okay. I guess it would be earlier than 7, I guess. Or, I'll be available either way.
We can start it. We can schedule it for 6 p.m. if you want.
Well,
It's up to everybody.
yeah, maybe we can discuss at the next POCD meeting, a reschedule of the POCD meeting on the 27th. Most of our big work will need to be finished up by the 24th anyway. So it might behoove us to move up the POCD meeting anyway.
So I'm available either way. So yeah.
I'm available.
Okay, well, great. So we'll see everybody on the 27th and tentatively 7 o'clock. We'll send you guys a meeting.
Yeah, we have to post notice, the legal notices and such. On that matter, we as a town, even though under the executive orders, we do not have to post notice in the local newspaper. We can just post notice on the website. As a town, we decided to continue the posting of notice in the newspaper. It's a 40-year practice. So until we have some other guidance or direction or another means of notifying the public that that system may change, we're going to continue with that. So.
Which brings us to item D.
we still have item B, Mr. Chair.
Oh, item B. Oh, I'm sorry.
Yeah, I skipped over because item A and C were the new applications received. Sorry.
Got it. Okay. All right. Well, that's fine. Okay. So yes, Mr. Garrity.
Thank you, Mr. Kirk.
Yes.
Hi. Just briefly, if I could touch on item A, just to give you a little quick background on it. That is also my client. That is a 3-lot re-subdivision. There are 2 existing approved lots. We have a 4th lot that's being carved off and donated as part of that application to the East Lyme Land Trust. We had gone before the Wetlands Commission last month. They conducted a site walk, made a conclusion that there was no jurisdiction. I believe they should have referred that to you, indicating that they were not exercising. If they haven't, I'll follow up with that. They did make some recommendations in terms of some changes to the design, which we incorporated into it as a result of the site walk, even though they declined jurisdiction because all the activity is outside the wetlands buffer. So, with that, I will go on to item B. Item B, we are in the process. This pertains actually to the entire remaining subdivision, but it in particular impacts a donation that we're making to, which a little bit more than a donation. It's a transfer of the property, a sale to the East Lyme Land Trust of approximately 36 acres behind the lots that are the application that will come up on the 27th. So there's an area behind this we are donating or giving to the land trust. There's consideration being paid. Part of that consideration is coming from the Department of Environmental, Energy, and Protection. And we have to issue to the DEP a title insurance policy. We have sent up preliminary policies to the DEP. They have seen the covenant, which the covenant says that the developer or its successors had to donate a minimum of 30 acres or create a minimum of 30 acres of open space. The developer and its successors have far exceeded that. That should be in the packet that you have, that in the January 7th letter to Mr. Gaishel. What we're asking for is a release of this covenant. And the reason in particular for the release of the covenant, I'll get to the conservation easements in a second. DEP will not accept the title policy that has this covenant in there, even though I've opined to them that I believe the terms of the covenant have been satisfied in terms of the actual amount of open space donated already. So it's been satisfied. They want to see it removed. I spoke with my title insurance company about issuing a title policy to the DEP and deleting this from the title insurance policy because we are of the opinion, again, that the covenant has been satisfied. My title insurance company will not agree to that. They said, get it removed. And DEP wants it removed in order to fund the grant for the property. So we're asking the commission to do one of 2 things, and I've draft releases in the letter that I sent to Mr. Gaishel on July 6th, to either release the covenant or execute a document subject to the commission's approval that indicates that the covenant has been satisfied, so it no longer acts as a cloud on the title, because we have additional land in there in part of the remaining undeveloped area of the subdivision that we intend to transfer to the East Lyme Land Trust as well. So we're asking for that. And I just asked Gary, can you confirm that that more than 30 acres have been dedicated either directly as open space or will be when, I think the land that's going to the land trust now is already, would be in excess of that, but we've already met the requirement of the covenant as to the open space.
Yeah, in terms of the open space for both, well, and it's confusing because there's the Darrow's Ridge property, which was
right.
Darrow's Road, and the Nottingham Hills, which is Kensington and Upper Kensington. So in regards to just Nottingham Hills, there's a parcel of land that was dedicated as open space on the north side of the Darrell Pond property, which is known as 16 Mostaway Road. So with that and the additional land holdings that they had that they dedicated as open space, they were already above the minimum requirement at the time. that was required by the regulations. So in that regard, yes, Mr. Garrity's right. They have met the open space allocation that was required by the regulations. And in total, this doesn't.
I think it's Exhibit B.
Yeah, I was looking
Excuse me,
at.
Exhibit A on the July 6th letter indicates the breakdown of the open space. Excuse me.
Yeah, I thought it totaled it all in total. Tallies it up each lot, but
I think we have a total of 41 acres already, 41.35 acres already donated.
yes.
So we're asking, as I said, I discussed with my title insurance company who has to approve the policy that I could delete it because in my opinion, I believe it's satisfied and they won't agree to accept that. And now that I've raised that red flag with them, they want to make sure they see something that says that it is in fact either released or that it's been satisfied. So that's what we're asking the commission in that regard for the covenant, which is spelled out in the letter. And I think it is Exhibit C, excuse me, no, that's the conservation, but it's in the July 6th letter. In terms of the two conservation easements, those were given by the prior developer to the town, and we're asking that those be assigned to the East Lyme Land Trust. And again, part of this just is for ease of future use where we're dealing with the land trust, and if we have to issue title insurance policies for anything we transfer, they act as an impediment to us being able to issue the title because the title company is saying, if the grantee, meaning the land trust, is subject to those covenants, how do we know that doesn't raise an issue from a claim standpoint down the road? So we're trying to clean that up as part of the remaining development in the subdivision. And there's a draft release a draft assignment in the July 6, 2020 packet that was sent to Mr. Gashel. I said it's the standard sort of form we use for assignments, but happy to address any comments or questions, changes that the commission might have if it's to approve that application. Oh, right, and I should point out, because I'm not sure if everybody's had a chance to see my letter since we got it. In terms of the transaction, we would be holding everything in escrow pending an actual closing and the transfers to occur, so that if that did not occur, we would return those documents to the town so that the town is still in possession and control of the easements. I should have mentioned that in case anybody was wondering.
Thank you, Paul. That was, yeah, that was, as I discussed this item with Mr. Garrity, we wanted a surety that, if something was to go sideways, the town wouldn't lose the easement. So with that, and basically, we're not giving up the conservation easement. We'd be transferring it to the land trust. And so that would have to be an act of this board, because this board approved the subdivision by accepting the open space easement. And again, in regards to the covenant, they did meet their open space requirement above and beyond the minimums that were required. So if there's any questions for me, I'd be happy to.
I have a question. I actually have two questions. The first question is, we have the town attorney reviewing this transaction, or is this completely independent of
No,
that?
the town attorney has not reviewed this, and actually the town attorney has indicated to us that they would decline commenting on this particular matter. So in that case, if the commission wanted to have legal counsel weigh in on it, we'd have to go out and find an attorney who would not have a conflict of interest.
Got it. Okay. So, and my second question is, the reason behind doing this is to make it available for the DEP to buy it and then hold it, or?
Yeah, yes and no. So the DEP funds the transactions.
Okay.
The East Lyme Land Trust will own it, but what DEP does is it puts its own conservation easement on top of that, so that even the land trust is prohibited from transferring or doing anything on the property that's inconsistent with the funding grant. So I did one. I don't know if anybody's familiar with Exit 7 in Haddam. There's the beaver ledges up when you drive down that long exit to get to Route 154. On your left-hand side, that's all owned by the Haddam Land Trust now. When we did that transaction, the funding to acquire that from the private owner came from DEEP, and DEEP required a title policy, a full survey. We have actually just sent the survey and the new legal description up to DEP this past week. And then DEP, as part of that transaction, superimposes or records its conservation easement over that, so that the land trust are bound by the terms and agreements in order to get that money. And obviously, the main thing that the conservation easement does then, that since the state owns it, it prevents a land trust from deciding to think that the property might be of value. They want to trade it, sell it, whatever. But it also has a lot of restrictions in there on what can be done with it, and positive things too, in like terms of trails and stuff like that. So that's how they get into it. That's why they want a title insurance policy. And as I said, they look at the covenant and say, no, we don't want a situation where the town would come and say, hey, lot 6 was supposed to have a sidewalk. Well, we're not lot 6, and we say that doesn't apply to us. Well, what about the open space requirement? You're supposed to give more land. What happens with us? They don't want somebody making a claim against their interest in that, so they want it removed. And as I said, my title company says either get a release or get a satisfaction from the town saying that the terms have been met, so that as in my opinion, I look at it and I say the terms have been met. So the covenant, I think by operation of law, is satisfied. That's not good enough for the title company because they are the ones who write a check if there's a claim. It's not good enough for DEP because they don't want to have a claim to begin with, period, whether they have title insurance or not.
Okay. And then the benefits to the people of East Lyme are pretty much the same as they would be if this transaction did not go through, right?
Correct. Yeah, there should be no impact on that. I mean, my understanding is the land trust intends to have some trails out there. There is public access on Upper Patagoncet Road to that. That is all going to be transferred to the land trust. And DEP will require posting of a notice and access point on it too. But the public access will be off Upper Patagoncet to the piece that we're conveying.
Okay. Does any of the other commission members have any questions about this?
I do, Kirk.
Good.
Michelle Williams. I just want to make sure I'm looking at Exhibit A in the memo, and I just want to make sure that I'm understanding it correctly. So the entire subdivision is just under 108 acres, and
Yes.
41 acres have been already conserved separately from what is pending in the application for which we'll have a public hearing?
Well, let me be clear. So 41 acres has already been preserved as open space. The application for the subdivision that you're going to see at the end of the month is 3 separate lots which have been approved as 2. This land is separate, but it's behind that, and the access is off the same street. It's going one way or the other. It's not dependent upon the subdivision.
But the acreage does not include any new acreage from that request. The 41.35 acres. Okay,
Yes, right.
great.
Right.
Thank you for clearing that up.
Sure.
So then after what if we did say that this item A gets approved, there's an additional so many acres that are also on top of that going to get transferred to the land trust as well.
Yes, there's an additional 1 acre. So in that application for the subdivision, it's presently 2 lots. We're proposing we divide them into 3 and peel off approximately 1 acre. That gets conveyed separate from the transaction that's part of that we're asking for Section B on. So that'll be an additional acre that goes in. I may have misspoke to Ms. Williams' point. That's going to be ultimately an additional piece of the East Lyme Land Trust property.
Okay, great.
And it's all connected.
1.35 has already been conveyed.
That's correct.
Thank you.
So there's anyone else have any other questions before I have a question?
No.
Okay,
No.
so my question now is, like, there's a lot of legal wording and legal descriptions of property and the releasing the covenant and other legal bits here. So in order to push this forward, what exactly do we need to, how do we have to phrase our motion? Gary, do you have any ideas about, because I could take a stab at it, but I don't know all the terminology properly, and
well, I think it would sound something like I would move to release the open space covenant recorded in East Lyme Land Records, volume 653, page 355, Exhibit A, as the terms of the open space covenant have been met with the dedication of open space with phase 2 of the Nottingham Hills subdivision. And then I would say, in addition, I could go on and commingle it with 2, unless you prefer a second motion on the second item. Which would be just the second item would be a motion to assign the conservation easement in favor of the East Lyme.
yeah, I mean, if we could come up with some, language, I mean, that is pretty succinct and to the point and accurate, that I think might be helpful. Because I would hate to get into a situation where the motion that we would craft is not valid or anything like that. So you were reading from something, Gary, when you were talking about that motion?
Well, I read from Mr. Garrity's letter.
Okay.
Read item 1, so it would be, just typical I move to, and then release the open space covenant recorded in East Lyme Land Records, volume 653, page 355, Exhibit A, as the terms of the open space covenant have been met, in that the dedication of open space with the phase 2 of the Nottingham Hills subdivision has been dedicated previously. Something to that effect.
Okay.
Mr. Chairman, may I just jump into, I think whatever motion gets approved, assuming that you do approve it, it ought to authorize you as the chairman to sign the document as well too, because it's being done by the commission itself, as opposed to in some other cases where it's done through the selectman's office.
Interesting. Okay. I would be willing to sign that as long as it's clear. I'd be willing to sign something like that. Is there anybody here that types really fast? Maybe they can chat the whole.
Well, we do have the draft release.
Okay.
In Exhibit B, that we could read aloud for purposes of the record and authorize you to sign it. Yeah.
Okay, I don't have that in front of me.
Okay.
have it in front of you?
I'm happy to read it if you'd like me to, or maybe
I
Gary
think if you
share
read it in a way that sounds like a motion, then that would be helpful.
Michelle,
Yes.
is that Exhibit B, request for open space release or open space easements? I'm looking at two.
It is Exhibit B in the document that is the July 6th letter to Gary from Paul. And Exhibit A has a list of all of the parcels. And then Exhibit B is a release of covenant, the actual release that Paul is proposing we authorize Kirk to sign.
Okay, I'm just looking at the list on the planning website for download.
Yep, it is item, there's, 3 different items. Oh gosh, yeah, okay.
Yep.
Garrity request for open space easements or PDF.
Okay,
So it's before the easement plan set.
and
It's,
after the open space release.
I believe so.
Okay, all right, thank you.
Yeah, request for open space easements. Yeah.
Okay. Got it, thanks.
So I'm happy to read it.
You want to read the whole thing into the record? Is that?
Yeah, I think
can if
that's a good idea.
Okay, so the release of covenant reads as follows. Know all men by these presents that East Lyme Planning Commission for consideration of 1 and 0 over $101 and other goods and valuable consideration does hereby release and remiss all its rights and title and interest in and to certain open space covenants between New England National LLC, Niantic Real Estate LLC, and the town of East Lyme, and recorded in the East Lyme Land Records at volume 653, page 335, to the East Lyme Land Trust. And then there is a piece where you have to witness whereof Torrance Family Limited Partnership has caused these presents to be signed on this, day of 2020. You fill in the date, signed, sealed, and delivered, and in the presence of. And it appears that it would be need to be signed by Kirk as well as a notary public.
May I point out one thing? This was an earlier version. It should say in witness hereof the East Lyme Planning and Zoning Commission. The Torrance Family Partnership was the party that actually granted, along with Niantic and New England, the original, or were subject to the original covenant. I think that would be the only change that would need to be made to the motion or to the actual document.
Sub out the Torrance's,
Right.
Torrance Family Partnership with the East Lyme Planning Commission.
Right, and if this is if it's going to be released, in the last 5 words where it said on the main body of the paragraph, it says volume 653, page 335. It could end right there because it's not going to the East Lyme Land Trust. It's just releasing it. That was a carryover from the assignments to the Land Trust when we were drafting the documents. I didn't catch that. I apologize.
Okay.
So I'm sorry, which part did you want to not put in there? The East Lyme records at volume?
So after, when you start at the volume page 653, page 335, it should end right there. The reference to the East Lyme Land Trust should be deleted,
Okay,
as well as the Torrance Family Limited Partnership. That was from an earlier version, and we were scrambling to get this in within the 24-hour requirement so that it could be posted. Missed
Okay.
that.
Do you want me to take a stab at drafting a motion and maybe putting it in the chat box, or how do you?
Sue, how did you do with catching all that? Did you manage to catch that already?
yeah, I mean, I do have that document in front of me now, the release of covenant with those changes. I didn't know if the motion was something like to approve the release of covenant and then reading that in, or if there has to be more to that.
Is there a way that you could make those edits and then drop it in the chat box? And then maybe one of us we can all read it before we decide it's a good motion or not.
Not that fast of a typer.
Okay,
I
all
can
right.
copy and paste. That's not a Word document that I'm looking at. It's on the town website. That's where I'm getting it from.
Oh, it's
I
not.
can put the link in the chat for everyone to see the document
Yeah.
that we're both looking at.
Yeah, because I looked for it and I didn't.
You have to scroll down. It took me a little bit. You have to scroll down on that particular.
I see the document.
So
Yeah.
it's Exhibit B of that document.
I
And
see
you
it.
have to scroll way
Yeah, I
down.
see the release of covenant here.
Yep.
Okay, I got it.
So just to confirm, again, just for anyone that can't see video, this is Michelle Williams. So I believe that I understand the release of covenant in concept. However, I do need to admit that I'm a little concerned about making or voting on a motion on a legal document that has not been reviewed by town attorney, even though town attorney declined to review it. I mean, this is an area that, I don't feel we're super well versed. Don't know if anybody else shares that concern.
Well, I do have a concern for that. The release of covenant could you remind us what the intent of that is?
So the intent, it pertained to two things: making sure that the developers provided a minimum of 30 acres of open space, and with lot 6 in the other part of the subdivision, that if sidewalks were requested to be built on lot 6, the developer would build them on lot 6. Lot 6 was then re-subdivided and it doesn't exist anymore. But there are some sidewalks in, I think the Darrow's Ridge side of this is where those were. There's no sidewalks in the upper Patagonia, Nottingham Hills phase of the subdivision. It's primarily and that's why I said at one point, a satisfaction in terms of the requirement of the open space. That's what we have with respect to the DEP. They're looking at that saying, we don't want to claim that somehow the open space we're paying for is going to be somehow subject to this covenant. It should be subject only to our grant easement on that. So even a satisfaction of the terms of that would be acceptable.
Right. So the point really is that they want to have it without any restrictions by the town.
Correct. I'm sorry. I mean,
no, go ahead.
Well, the covenant dates back to one of the earlier phases of the subdivision in 2003, and that 40 acres that we're talking about was donated in 2004. It's just been out there because between the delays and the various phases and so forth, we haven't gotten to it until we got to this point.
Okay, so I understand that part of it. And then if we do release the covenant, then there's a period of time where you say that before it gets transferred, there's a period of time before it gets transferred to the East Lyme Land Trust that there was some concern about it going, the deal falling through or whatnot. It would be in escrow so that it would automatically revert back.
Right. And Frank, in terms of holding it in escrow, I'm happy if Gary held it in escrow. I mean, we had said in our letter we would hold everything in escrow because if we have to undo the transaction, we need to put everybody back to where they were prior to that. So if for some reason Deep said, look, we've decided the grant's not going to happen, then the East Lyme Land Trust isn't going to be purchasing the property, at least not through that process. So we would have to return the documents to Gary or even, as I said, the town could hold the documents, and when we get the closing together and we go to record, we could show Gary or whomever, here we are, we're about to record, we've got the documents, can we have the covenant to file in the land records so that I can issue the title insurance policy? You know, I'm happy to do what makes you folks feel comfortable in terms of that. You're not going to release something and not get something in exchange for it, obviously.
Oh, yeah, yeah. Well,
Well, I think,
normally when you do a real estate transaction, like you have 2 lawyers.
Correct.
So now there's only 1 lawyer there. And I see where Michelle's concern comes in, but on the other hand, yeah, I understand the escrow parts. Gary, do you have any insight that might kind of provide some assurances to us that, you know, speaking to Michelle's concerns?
in regards to having an attorney take a look at these documents.
Right. I mean,
I think the best thing I can say is that the open space that was required by the subdivision approval is already allocated and is held by the town in a conservation easement and or fee simple. So that's in regards to this lot. It's just excess acreage above and beyond what was already dedicated. So, and if you actually read the, you know, I think it was in the covenant. I had it here. It talks about the sidewalk. I don't know if you guys read through the document, but basically what Paul's saying is in the event that we don't need the sidewalk and we don't need the excess open space, the land is, we no longer need to hold this covenant. So I mean, without legal counsel, I can't say, you know, I'm not an attorney, so I can't speak to it in that regard. I mean, I can just tell you what I know is I do know that the subdivision has met the requirements of our regulations. I do know that as a result of all of these transactions that the land will eventually, there are parcels that don't have public access currently, will ultimately have that access as a result of the DEP easement. So that's kind of something that we gain. Or Mr. Garrity say that the land trust has interest in putting trails and things like that out there. You know, if it's the commission's pleasure, I mean, I think you could do a couple of things. You could go ahead and move to release the covenant and go forward with this, you know, maybe contingent upon review by council. Obviously, our town council, we have to go out and find an attorney who could review it in short time. You know, it's, you know, and assuming
are we bound by any time constraints here? I mean, how is that?
Yeah.
We the town are not necessarily constrained by any time constraint, but obviously the buyer and the seller have their deal probably scheduled sometime in the near future. I don't know when that is, but and they have to coordinate with state agencies as well. So
yeah, there actually, I think there are 2 time constraints. There's a time constraint in terms of from our submission. I haven't done the math on that in light of the executive orders, but I believe that because we submitted the request in January, and there were, and you know, I don't want to go down that road. That's not my preference to go down that road and say, look, you know, we think it's been released, whatever. But setting that aside, we do have constraints with DEP in terms of getting the grant through. And we actually received an email from DEP a few weeks ago saying you need to move on this because they want to get the grant money out. I don't know whether internally there's a fear that the governor is going to start looking for funding sources given the shortfalls and so forth. But, you know, they made it clear to us, you know, get this project moving. So if we look at, so if I were to look at this in terms of the permitting and just under the regular statutes, it's 65 days from when it's submitted. It doesn't require a public hearing or anything like that. So I think the executive orders extended it, but I'm not sure if we did this in January. whether they even apply to us at this point in time. And again, I don't want to go there. I get it, things happen that nobody could anticipate. But, from our perspective, we made the request back in January. The commission met a couple of times. It wasn't addressed, and I'm not blaming anybody for that. But we think that you really need to move on this. And I'm not trying to force you to not retain counsel or anything like that. But I also think that what we're requesting in terms of the documentation and so forth, in light of what Gary said about us having met the open space requirements, is we're really there, and it's not that complicated a matter. Like I said, if the commission wants to file something that says we satisfied the terms of it as opposed to a release, if that makes them more comfortable, that would actually have the same impact for me in terms of writing the title and getting the DEEP grant finalized.
Thank you for that clarification.
Okay, so that's the covenant part. And then there's another part to this thing that we have to kind of talk about too. Right?
Right. Those would be, there are 2 conservation easements on the property, and we're just asking that those be assigned to the land trust. Since much of the property going forward that's subject to the conservation easements and the additional land we're going to be granting is going to the East Lyme Land Trust. And that's, that draft assignment is in Exhibit E of the July 6th letter.
Got it.
Can't get a split screen up here with mine, so I have to try and go back and forth between the documents and the Zoom video.
Yeah.
But in that respect, a motion that essentially recites the language in there, that this one doesn't have any typographical errors in it, would satisfy, I think, but the exception of, again, it has the Torrance Family Limited Partnership, and it should say the town of East Lyme. But other than that, it would effectuate a motion.
So, okay, I'm looking at the top of this exhibit. You're talking about Exhibit E.
Right.
Okay. Oh, that's not that long. Okay.
Yeah.
I was looking at the one before it. There's a lot of words on the other one.
Right. And there is Exhibit F is a letter from the land trust saying that they would accept it, which is one of the requirements under the zoning regulations.
Great.
That I'm comfortable with. Does anyone have any other questions about this assignment of easement?
I've been working on some draft language as you guys talked. I don't know if you want me to maybe
Yeah, please do.
post that into the chat box. I can.
So it's Niantic LLC, Niantic Real Estate.
Right, so there are two easements. One is between New England National LLC, Niantic Real Estate LLC, and the town of East Lyme. And then the second one is just between Niantic Real Estate and the town of East Lyme. And that related to the various phases and which entity owned those phases as they were being developed. They are related entities, though.
So we're releasing those.
No, you're assigning those to the land trust.
Oh, yeah, okay.
Right.
Okay. See, this is where the language gets
Right.
important.
No, we understood. We're not asking those to be released. It's just that now, since the land trust is acquiring some of the other properties, having one entity that is responsible for all the easements out there makes life, from our standpoint, easier. And it also obviously gives the land trust a larger, from their perspective, they're now in charge of everything out there, and with the land they owned outright and with the land they have conservation easements on, makes it easier for them, I think, to plan and act accordingly.
Right, and it's more meaningful as far as open space goes to have a contiguous block of land.
Right.
Makes
Right.
a lot of sense.
Yeah.
Well, to clarify though, it's already open, right? Just under different.
Right, but there's some questions about whether or not it would be accessible. So that's one
Got
of the things that we would get from the DEP involvement would kind of ensure, like they have, what is the language? Does anybody have the language that the DEP might include as part of their easement?
I can only tell you from my past experiences, we're working with DEEP on these things, is that there are requirements that for public access, trails, and the like, in order to open it up. That's one of the main reasons for the grant. I think they have, I'm going to butcher the term. It's a technical term regarding forest husbandry. Let's leave it at that. I won't try and use the term for what a forester would use, but maintaining invasive species or keeping them out, dealing with dead trees, things like that.
Okay. How you doing, Gary?
All right, I just
Oh,
posted
you
it
got one.
Oh,
chat box. Now, I used I started that with move to find in terms of the open space covenant recorded on the East Lyme record was met. You could say, if you were comfortable with releasing it, you could say we move to release the restrict. You could interchange the words. It would change a little bit, but
And I believe they were talking about, Mr. Garrity was talking about some language on there for me to sign something, right?
and then you would include, and to authorize the chairman of the planning commission to execute the agreement. Would you?
Yeah, I just, because somebody has to be authorized to sign on behalf of the commission, so I think that ought to be set forth in the motion.
So the little addendum on the end would be something like, and authorize the chair, my name, Kirk Scott, to sign as authorizing such, or something like that.
Yes, that would be fine.
To execute the agreement.
Yeah.
Yes, that's much better language. Thank you.
nice job, Gary.
You want me to add that
And authorize the chair, Kirk Scott, to sign authorizing execution of the agreement. I think that's what Sue said.
Kirk Scott to execute.
Authorizing that the terms have been met.
little typo, but
Okay.
little typos. And just tag that to the end of that line, and I think that would do it.
Okay, so that's part one.
That's part one. And then part two, looks something.
Is assignment of the easement to the East Lyme Land Trust. And as they have agreed to accept the easement.
Mr. Chair, are these two separate motions?
Yeah, I'm going to draft the second one.
Yeah, I think so.
Should we get through one and go to the other, or?
Yeah, I think that we have enough that we can maybe. Do I hear a motion? I'm calling for a motion.
This is Michelle Williams. I move to find the terms of the open space covenant record on the East Lyme Land Record, page 653, or I think section 653, page 355.
Yep.
As the terms of the covenant have been met with the dedication of open space as part of the phase 2 of the Nottingham Hills subdivision, and I hereby authorize the Planning Commission chairman to execute, I think to execute a letter as such, or authorization.
To sign the letter.
Right, because you would be putting in writing that the terms of the covenant have been met.
And you could say to execute the release of covenant, or
Yeah, okay, and to execute the release of covenant.
Do I hear a second?
I second. Richard Gordon.
Discussion? Yeah, I think the only thing I would have to say is I'm thinking that if we pushed off too long, the state might not actually have money to do this. That's my only concern, especially given the financial hardships that are going on. So that's my only 2 cents. Does anyone else have any discussion or thoughts that they want to share? Okay, with that, all those in favor, say aye. Let's get down the list. Michelle?
Aye.
Richard Gordon?
Aye.
Michelle Davis?
Nicole Davison,
Oh, I'm
aye.
sorry, Nicole. And Kirk Scott, aye. Opposed? Abstain? Okay, so let the record show that motion passed. And let's move on to this next section, the assignment of easement.
so my packet here kind of got disheveled. I just want to make sure I get the right easement, Mr. Garrity. So the easement that you're looking to transfer, is that book 742-502? Because the other easement I had was
So there's two, Gary. The first is at page 870, 689. The second is the one you just mentioned at volume 742, page 502.
okay, got them both. All right, just making sure I have them both. Okay.
So that page there on Exhibit E, that's correct. Those page numbers and volume numbers.
Yes, the only difference on the assignment, we'd have to delete the Torrance Family Partnership and say the East Lyme Planning and Zoning Commission.
Okay.
And I'm happy to do that. I can get that to Gary tomorrow.
And
So with this, you would be asking me to sign this one as well?
Correct. And again, this would be held in escrow pending our closing with the land trust.
And so I guess the question is, as I type this, I'm at the point as to who's going to hold, I guess who's going to hold it in escrow, the attorney or the town?
I think it would be okay to have the town do it. I think.
Yeah, that's perfectly fine.
Any suggestions to the town of East Lyme shall hold an escrow of, any way to make that simple?
What I was thinking I could do is I'll just pick them up when I go to record.
What?
I'll pick them up when I go to record. And that's it. Yeah.
Well, the covenant, covenant, they should give you now. I mean, we've satisfied it.
Yeah.
It's the only one that's, you know.
Right. I think they want to be protective that they haven't done anything, but if I can just pick them all up when I go to record, we should be fine.
Tell them that.
Yeah.
Well, we need a provision in there that allows us to get them.
Yeah.
So we don't get held up.
Right.
We'll be chasing Gary.
Mr. Garrity, what would you use for terminology here, that the town of East Lyme shall hold in escrow the?
So what I would suggest, the town will hold the release of the covenant and the assignment of the conservation easements in escrow pending the recording by Paul Garrity of the closing documents, at which time they'll be released to him to record. And that way, Gary, when I show you I'm recording, you should be able to just release the documents directly to me.
This is Michelle Williams. May I just ask who's speaking off camera? Typically, we would see that person if we were in person, but I hear another voice.
Oh, I don't know if you heard, one of my clients is here though. And I was actually talking to them, so.
I don't
know if it's anybody else. I'm not sure who you could hear, but
I was hearing you. So I was just wondering just if we needed to include that in the record because it's an unusual situation being on Zoom. Typically,
yeah, I know.
That conversation would be public. Yeah.
All right.
All right. So I posted in the chat box a draft motion, if you will. I think that's pretty good, minus my spelling. It's hard to type in the chat box because it's so small. Anyway.
Okay, so has everyone on the commission had a chance to review that? I'm going to assume yes.
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 Okay. Does anyone care to make a motion?
I'll make a motion. Richard Gordon. Let me read that. There's a motion.
Yes, please.
Okay, I make a motion to move to assign the conservation easement in favor of the town of East Lyme, recorded in Book 742, page 502, and Book 087, page 689 to the East Lyme Land Trust, and to authorize the Planning Commission Chairman to execute said agreement, and the town of East Lyme shall hold in escrow the release of the covenant and assignment of the conservation easement.
I think you just need to add pending recording.
Pending recording.
Pending recording, and I believe the book number is not correct.
No?
There's
742, 502, the other.
There's a typo. It should be 870, not 087.
Oh, sorry. Yes. So I would just note, did we get a second, Sue?
We haven't gotten a second yet.
We'll wait till we get the second and we can discuss it.
I second Nicole Davison.
Thank you, Nicole.
As previously mentioned, yeah, that is a typo, as Mr. Garrity pointed out, so it should be Book 870, not 87.
Do we
Just
need to
question.
redo the motion, or will that stand like that?
I think it would stand like that. I think you just to edit, and then as it gets recorded, right, Sue, do they have to repeat the motion again with the change?
No, I don't think so. I just want to make sure that book is the same as volume. I'm looking at the assignment of easement, and it says volume. So I just want to make sure that those are the same.
Yeah, again, it depends on which one you look, because one will say book at the top when they clerk stamp it, and the other says volume.
Okay.
But just know it's not book 87, it's volume 870 or book 870.
Okay.
Okay, I'm gonna, any further discussion? Okay, so I'm gonna go down the list. And we can vote. Michelle,
Aye.
Richard Gordon,
Aye.
Nicole Davison,
Aye.
thank you. Kirk Scott, aye. Opposed is no one, and abstained is no one. Let the record show that that motion carries. Thank you all for that. That was
Thank you. Appreciate your time and effort.
okay. Thank you very much.
I will leave the meeting then. Thank you.
Have a good night. Thank you.
You too. Well, take care.
Okay, so thank you for everyone for that. That was a bit of work.
So we're back to, I think we're at item E, which is bylaws and the subdivision regs, fees, and discussion.
Right. Okay, so the bylaw, so we're on item D, or do you want to do,
Oh, sorry, item D. Jeez,
yeah,
item D, very important.
okay. So this is application of the Town of East Lyme Inland Wetland Agency for a text amendment to amend section 2.1 of the East Lyme Inland Wetland Regulations to change the definition of a regulated activity by enlarging the distance of the boundary for a regulated activity from 100 feet from an inland wetlands and or watercourse to 500 feet. So what is our charge with this one today? Are we, I thought that they took input from us. They don't, like, we're not necessarily having to, you know, say it. We don't necessarily need a motion on this one, do we? I guess
Correct.
that's my question.
The wetland agency is not obligated by statute to send a referral to the planning commission or any other board or agency other than to provide notice to the DEEP I believe it was ahead of, I think it was 35 days ahead of the public hearing to consider the change. So that's the only notice requirement that the agency is required to fulfill. That said, obviously this is a significant change. I advise that agency to provide referrals to the applicable land use boards and commissions, as well as the Board of Selectmen, just for public input. So while we don't have to furnish a formal motion or resolution, we can furnish a letter. If the commission has a consensus or whatever feelings of the commission, whatever you feel that is appropriate to send to the wetland agency, you can certainly do. You don't have to comment either. That is also an option.
Okay. Well, this is good that they refer to us. It's an act of good faith on their part, and I think it was a good idea to try to get input from the different boards and commissions, and I applaud them for that. So do we have some background as to what the impact is? My first question about this. What, compared with where we are now, 100 feet from a wetland or watercourse versus where we would go to 500, do we have a sense of what the percentage of the town this might be? Because it seems like it would be quite a lot.
I haven't calculated a percentage of town. What I have done is I have put together a map that shows the 100-foot upland review area versus the 500-foot upland review area, just around the watercourses that were identified by the DEEP data. So we have a layer in our GIS system of watercourses throughout the entire town. So when you apply the 500-foot upland review area to that, it blankets almost the entire town. There's a handful of areas that are not encompassed. So looking at that, if you were to apply a 500-foot upland review area to the inland wetlands layer, the entire town would just be blanketed by a review area.
Do you have that map handy?
I don't. That's the one map I don't have handy.
Sorry.
I will have it for the public hearing.
Okay.
I printed it out the other day. I printed a hard copy and not a PDF.
So this, like, you guys had this discussion at Wetlands, I'm sure.
Brief discussion. The agency had worked for a good year and a half on developing and basically overhauling their regulations. The proposed regulations were going to break the permit process into 3 parts, where you would have minor permits that would be administratively issued by staff, and then intermediate and significant permits. Basically, the 3 levels are what can be issued by staff, what can be issued by the commission without a public hearing, and what's going to be issued by the commission with a public hearing. The idea was that it was going to provide the applicants more guidance as far as what they could expect in terms of the process. And I think it also kind of breaks out the level of significance in terms of the use and the activity that's occurring. A deck and a shed, it does not necessarily always escalate to a significant regulated activity. So that was the big change. And in the discussion that the agency had, there was discussion about, I think it was Bark Hampstead, who has a 500-foot upland review area around vernal pools, and a 250-foot upland review area in certain cases where the slopes exceed 25%, or maybe it was 20%. But it was a very specific criteria that extended the upland review area. And that was mentioned, and upon that mentioning, the motion was made to consider just a 500-foot upland review area and looking at the remainder of the changes at a later date. So that said, that's what got approved to go forward at public hearing, and that's what we're discussing Monday night. The implications of a 500-foot upland review area are big. You're going to, in my opinion, will essentially require everyone who applies for a building permit to automatically have to make application for an inland wetland permit for their proposed activity with a blanket 500-foot upland review area. So essentially, I mean, while not everyone in town will apply for an inland wetland application and make a permit, but the majority of residences will have to, with no matter what they want to do. So understanding that, you know, that the town has 9,000 plus parcels, it's roughly 33 to 35 square miles. I'm sorry, not square. 30 square miles. Sorry, it is square miles, right? Okay, sorry. Anyway, point being is it's a large land area and mass, the geographic area I couldn't cover as an individual agent is what I'm getting at. The ability for the town to provide the staff resources currently are not present. So if this was to get approved and they set an effective date, say 15 days after the appeal period, the town would have to hustle quickly to hire staff, I think, to fulfill it. I don't think physically I could physically do it. It's just every permit. Again, if it's just a blanket, yeah, I can issue it. We can come up with procedures and policies and just crank out paperwork. But then what are we really doing? We're just cranking out paperwork and generating revenue. Are we really improving the environment? So, I've held that, and I've recommended the agency consider looking at low impact development methodologies, construction standards, and require those items and things like that nature versus increasing the upland review area. DEEP documentation that's available on the DEEP website, in the Water Resources Bureau. Their documentation and guidance indicates that a 100-foot upland review area is sufficient in that we have planning and zoning commissions who also have oversight on environmental issues. And that said, as DEP describes it, the Inland Wetland Agency is an administrative agency, not a little EPA. So that's the kind of the coined term that people will refer to is when wetland agencies want to start regulating beyond just the inland wetlands and watercourses and their jurisdiction, and they start acting like an environmental protection agency, and that is not their job. That would be the job of zoning and planning to act in those regards based on their regulations. So, there's some concerns with that in increasing the regulated area. Again, the administrative permit fee is $160. So, it's effectively, you're going to generate, you can multiply that times 9,000 parcels, right? And at some point, maybe you'll generate that revenue. Again,
how many building permits do you issue or are issued every year?
Maybe on an annual basis, probably right now, 20 to 25 is what, plus or minus. I can go back and actually calculate that for you if you wanted. But just off the top of my head, I'm thinking it's about 25.
25 building permits?
No, 25 inland wetland permits. That includes commission approved applications as well.
Right. So I guess my question that I'm getting at is like, if most of the town is blanketed by the new 500-foot upland review area, then you would take pretty much every building permit and add $160 to it or whatever.
Plus or minus, yeah.
Is that what the fee is, I think?
The current fee, again, they're not proposing to change their fee schedule. So all the work that would fall under that minor administrative permit would be quite a bit, I think.
And does this does not preclude people from from building in the wetlands. I mean, you could get a permit to build inside of 100-foot upland review area now. Is that correct?
Correct. So under in the wetland statutes, you can conduct activities in the wetland in a watercourse so long as you obtain a permit. You can conduct activities adjacent to those so long as you can get a permit. And currently that area adjacent to those wetlands and watercourses is 100 feet in East Lyme, and most towns follow suit. But there are a handful of towns that have different circumstances, and they've identified watercourses or water bodies of significant concern in which they've increased the regulated areas around those. So for instance, one suggestion I would have would be maybe if we're concerned about aquifer protection, because that's where a lot of this concern is driving from. We've just had the Costco development, right? And we've seen the comments how it was built on top of our aquifer. So that said, if we're going down that road, maybe looking at, as I said, the low impact development standards and improving those things. But just lost my train of thought. Give me a second.
Yeah.
Aquifer. Sorry, Kirk.
No, you're fine.
The question you were asking me again was just.
Well, it started off.
Had a point.
I started off with the question of how many building permits, and you went down the path. Oh, we talked about that for a minute, and then we started to get down the path of low impact building methods.
Oh, the particular water body. Sorry, thank you. Okay, so for instance, Lake Patagonia, it would be a suggestion maybe from the Planning Commission to the Wetland Agency that they consider that they increase the regulated area around that particular lake, maybe Powers Lake as well, even though that is surrounded by the Yale property. But Lake Patagonia experiences more development pressure, but it also sits on top of our aquifer, right? It is the aquifer at the surface. We've all heard Mr. Carlson indicate that. So to me, if we really want to be proactive, maybe we increase the regulated area around Lake Patagonia or maybe particular wetlands in that area of town. That might be something that the commission could look at if they're looking to try and enhance the protection of groundwater. But at the same time, that is not within their jurisdiction. The inland wetlands and watercourses are. And those are defined by soil types and for wetlands and having defined channel embankment and some other characteristics will define a watercourse. And that's it. That they unfortunately don't have jurisdiction over groundwater. So my thought would be, if you wanted to look at that, look at your APA map, the Aquifer Protection Area map, look at the wetlands surrounding that area, and where would it make sense to increase regulated areas? And are those areas in commercially zoned areas of town, or are they in residentially zoned areas of town? So looking at the type of land use that would be impactful, single family residential is not nearly as impactful, say maybe as commercial, although, truth be told, it could be completely the opposite, right? You can't police homeowners. You can at least police the commercial development. So it's a little easier, I should say. I can't always police them, but they don't listen, but sometimes they do. And it's a lot easier working with them because they're an organization. Does that make any sense? I mean, I don't know how to better to express or explain that, but dealing with your homeowners, you can't police them. So some, I know you hear the stories, we used to change the oil and just drop it in the driveway, So if the town can't police that, the wetland agency can't police that, then I think, maybe, something smaller. I don't know. I'm kind of rambling now, but
Right. No.
if that makes sense. The other concerns, again, is just, what kind of burden does that leave the residents of town? Those who don't currently require permits will now have to make application to get them. The other question is, what impact to land value, if any, is there? The question is, if I didn't have to get a permit to begin with, right, my land typically looks more appealing. And now that I have to get a permit, that's one more hoop that a prospective buyer has to jump through. So does it decrease the value of the land? Does it increase the value? Those are questions that I think that the wetland agency, unfortunately, will have to weigh. And whether or not they weigh that into their decision making. The other issue, while they wanted to make some changes to their regulations, I guess my question as staff was they weren't clear on the particular reason as to why they specifically wanted to increase it to 500 feet versus, say, 200 feet, which was discussed at the subcommittee level. I don't know what the rationale was behind the pick
That
of
was
it.
one of my questions I was going to ask you, is what, why they picked 500 feet instead of maybe even something like 100. I mean, I could definitely see increasing it. I would just want to know where's the, I don't know, what would you, what's the time that says 500 feet is the correct answer?
Right. I haven't, in my attending classes and seminars and workshops, I've not run into any professionals suggesting an increased upland review area was necessary. It is something that can be looked at. The 100-foot upland review area that's recommended by DEEP in their model regulations, I believe comes from somewhere around, is it 1996, somewhere in there. So the 100-foot upland review area across the state was recommended, while some towns had 50 feet. Towns were adopting the 100-foot standard in the late 90s. And then as we went through the 2000s, it was just that was protocol, 100 feet. Can that be looked at? It's been 20 years, certainly. But again, I don't know where the science is that supports increasing that regulated area. I don't know what, it's hard for me to understand what increasing the regulated area actually will do in terms of the protection of inland wetlands and watercourses. Certainly, it would allow the agency to review nearly every application that comes through the town hall. I don't know that that's necessary. That creates a cumbersome land use process. But that's up to the policymakers.
I seem to be hogging all the questions here. Does anybody else have any questions or thoughts? I know, Michelle, I know you have something to say about this.
I have some thoughts, not questions. I think Gary did a nice job walking us through how the agency rather got to this recommendation. I guess my main thought is that, and I think at the beginning of this discussion, you noted that we're not necessarily looking for a motion here. So knowing that, my main thought is that I would be of the preference to empower the Inland Wetlands Agency to make their own regulations in the same way that the Planning Commission would want to be empowered to make our own subdivision regulations, right? Ultimately, they are the agency that is accountable to their recommendations. So as a Planning Commission member, I can certainly have thoughts on their regulations, but would not want to provide like an official seal of approval or, disapproval, because they are ultimately the agency that should know their regulations and its impacts the best. That's what they're there to do. So that's my initial thought. some
Can
other.
I kind of
Go ahead,
dovetail
please.
onto that a little bit? As the planning commission, though, if they ask for our opinion related to this, we should provide them an opinion from a planning commission point of view.
Yes.
That I think we could all agree on that.
Are they asking for our opinion though, or are they just giving us notice?
Well, it's not clear from this bullet number D exactly how far or how set they are on making this change. It's just yeah, they're just saying they're making an application to change it.
So yeah, I think whether or not you had the opportunity to watch their meeting in which they rendered their decision to go forward with this change, I guess the question is, no, they're not required or obligated statutorily to send the agency a referral. So I would agree. I think staying away from what they do with their regulations is up to them. I think the planning commission commenting on maybe, hey, if you go ahead and do this, please be advised that these are things you should consider, right? I mean, there's staff resources. They may not be considering staff resources. Does the town even have the ability to fulfill that request?
Well,
Right.
I'm assuming that as the inland wetland agent, you are giving them the same feedback that you are giving us.
Correct. Although I can put a different hat on and talk slightly different, and I can talk about, the conversation changes because now we're talking about their regulations and what they do with them.
Right, absolutely.
What or shouldn't do. But again, that's not up to me whether they should do this or that. It's up to them what regs they'll adopt.
Yeah. There was a few other things you said, Gary, in your explanation that I thought were worth noting. You mentioned the impacts to property values. And I was curious about that because that has been something that we've been, advised previously to not include in our decision making. Otherwise, that would be a regular conversation at all of our applications, not in my backyard. So that's not so much a concern for me, although I do understand what you're saying. I don't think that it would weigh into any kind of recommendation or feedback that I would give. I also don't know, environmentally, and these are just random thoughts, so don't think that I'm going to one way or another. I'm just bringing up additional things to talk about. You mentioned that planning and zoning have other, administrative functions over environmental issues. But when wetland applications have come up in the past, it has really been, well, if inland wetlands approves, then there is no environment. Where in our regulations does that exist? To me, the way the regulations function, they are the primary, if not sole, environmental regulator.
So in response, the inland wetland
For me, I'm missing something.
the wetland agency only has jurisdiction again over inland wetlands and watercourses. They're not the EPA. They're not the environmental regulator. We have a Natural Resources Commission who has no jurisdictional authority over land or anything like that. Their charge is to inventory the open spaces in town and provide feedback to the Board of Selectmen on different environmental issues. For the Planning Commission, in our subdivision regulations, we address the environmental issues with our stormwater regulations. It's sprinkled throughout the document.
Yep.
Applicants have to meet this criteria. We can get more restrictive on that and say, hey, we should be doing a better job. And maybe that's the discussion that will come out in the near future as we create a subcommittee. Maybe if we do that, or we talk about the regs. which is next up on the agenda. So we have, I mean, that's about it. That's in terms of what the Planning Commission has for environmental oversight. We also have our POCD, which in it has our coastal area management plan, along with a handful of recommendations for environmental protections. Then it would, you know, I don't know the zoning code by heart, but I do know they do have provisions in there for different aspects of the environment. For instance, flood zones and so forth, we have a specific code for building in a floodplain. Now, again, could they do a better job possibly at you know, beefing up their regulations so that they're more environmentally friendly? Absolutely. Mr. Mulholland and I have discussed drafting new stormwater regs for the zoning commission to consider, very similar to that what we have in our subdivision regulations. You know, again, what we put in our subdivision regulations were adopted in 2008. At the time, it was cutting edge, if you will, for lack of a better term. I'm not exactly certain why zoning wasn't necessarily as receptive to adopting similar regulations. They have their reasons, but as Bill and I have been talking, again, we can see from you know, public sentiment, it seems like, hey, the town needs to maybe start cranking up on the environmental piece here. And so Bill has approached me and said, maybe we should start taking a look at the stormwater regs that you have in planning and apply them in zoning possibly. So that's something that's going to come forward. You know, again, I'd have to comb through the zoning regs to find out where else they have and they speak to environmental issues. So I don't know if that clarifies it for you, but at the same token, I understand where wetland agencies, being that they're the only environmental group, if you will, or they're the agency that's perceived to be the environmental group to protect the environment. Unfortunately, they just don't have the jurisdiction to do so. So I think, you know, what do we do going forward? Well, we can just beef up our plan of development in that regard, so that it does make land use changes, such as zone changes, more difficult to be had. I don't know. I mean, those are things we need to consider and talk about. But
Right. But that's not a policy document either. I'm not arguing. I'm just saying, like, we're getting down a road of all these things that would individually require their own, you know, public hearings and public vetting and committee decisions at a number of different boards. So I understand the other options toward protecting wetlands and the environment outside of this issue. Because, you know, sticking to the proposal at hand. I don't know. I guess
just realized something. Can I interrupt you just
Yeah.
1 second? Sorry. Elizabeth Allen, are you still there?
yeah, she's been muted.
Is it
Yes.
too late to see her?
I'm here.
Hi. I didn't know you were here. Or else I would have asked you if you wanted to be seated. And my apologies for that.
Oh, that's fine. I don't know what that even means, seated. What does that mean?
Well, it just means that you would be participating in the conversation, and we would. We're probably not going to vote on anything tonight. The rest of the meeting, we could take you off mute, and you could participate if you want. Would you like to be seated?
I honestly, I don't even know what that means. I'm here. I'm listening.
Okay. All right. Well, thank you for being here.
I would just go ahead and seat her, Kurt.
I wanted to stop and just say that because I overlooked the fact that you were there, and I apologize for that. So.
Oh,
Thank
okay.
you.
I just thought because I was an alternative that it didn't. I only needed to be if there wasn't enough people or whatever. So that's fine.
Right. Well, normally if somebody doesn't show up, we would seat you, but it's okay. We're not going to vote on anything, and we do appreciate you and thank you. And please stick around for the rest of the meeting. And I'm sorry to interrupt the flow of thought here, Michelle.
Oh, yeah, of course. Would love to know what others think too. I mean, just to summarize my turn and be done. I mean, I definitely support changes to the inland wetlands regulations. And I'm taking Gary's word for it that the 500 feet would blanket the town. I do support changes, but knowing that the Inland Wetlands Agency is ultimately responsible for being accountable to these changes, I would want to empower them to determine what those changes should be after going through their process with their own public hearing and their own internal discussions and debates. I'm not sure that I have a feeling one way or the other about the specifics of the 500 feet, but I do think that our inland wetland regulations can be modernized and updated to better protect some of our critical waterways.
Yeah, I would agree with that thought. I mean, it does seem like a good idea for them to revisit and revise and do the right thing as far as protecting our environment. And unfortunately, I don't have a background in environmental engineering or anything like that. So for me to weigh in, the only way that I'd be able to weigh in on any of this stuff would be from the perspective of what the effects are going to be on the town in relation to the POCD, which my opinion is that it's both consistent and inconsistent. It's consistent because, we're planning for the future and trying to preserve our resources by protecting them. It's just, my question is, are they really going to get the amount of protection that they think they're going to get by increasing it to 500, where maybe 150 might be a good number? So my only thought would be to maybe have them, and I'm sure they're going to do their research, so I can't even say have them do research. I'm sure they're going to research this and find out what they feel is the best number. But I feel like we should make some kind of statement that says it's both consistent and inconsistent with the POCD. Does it? That would be my only other thought. Rich or Nicole, do you have any thoughts?
Kind of agree with what everyone's saying. I guess we have to. I'm sure they're studying the regulations, and I don't know if 500 feet is the correct total. But Michelle was talking about wetlands would eventually have to make a decision on that matter with our input, I guess, to a certain extent. But.
Yeah.
I mean, again, the commission doesn't have to weigh in, doesn't have to comment, although I think it is just because it's a significant change. If it was to be approved, and I think it would have a significant impact on the town. Whether that's adverse or positive, that remains to be seen.
Well, let's see. Anybody else have any thoughts? Nicole or Elizabeth? Anything anybody wants to add?
Well,
Gary, any other thoughts that you?
Well, I think if you were to furnish a letter or something, I think the way Michelle worded it, maybe you come in with a statement to the effect that, hey, you're neither, because I'm just trying, it's so wishy-washy sounding, you're neither for or against, but you're in favor, I think is what you used, of updating and modernizing the regulations to better protect, and I use the word water resources. But maybe that's, you go forward with something like that. It's relatively, I hate to use the word benign, but you say, hey, and in doing so, do your homework, do your research. Yeah.
Well, there's definitely perils on the other side that, contrary to the good, there's certain amount of things that are going to happen as a result of this that are not good. But you have to frame it in the right way, because it might be protecting the environment, but it's hurting some other part, of our economic well-being for the town, or
Right, but when you look at that in terms of the wetland regulations, when they're evaluating an application, they're not looking at the cost.
yeah, that's true.
Very infrequently do they do that.
Right.
That said, when an application gets appealed, ultimately the judge says it doesn't matter what it costs. However, when they use the word feasible and prudent alternative, well, feasible means how likely can you do it? Well, if the project cost was $100,000 doing it my way, but if I got to do it the way the agency wants me to do it, and it's going to cost me $1 million, well, that's not prudent nor feasible. So in the court systems, they'll look at that when it comes to cost, if it's like grossly divergent. But if you're talking, hey, a couple $1,000s, 20,000, 30, I mean, that's not, maybe for a single family homeowner on their project, but if I'm trying to put this in the context of a large commercial development, let's say you take a 5,000 square foot building, right? This is what you're looking at. And yeah, you're not, the costs are nominal, I guess, when you look at it in that kind of context. But to a single family homeowner, it might be a lot, how does that impact, sure, it has an impact on the economy. But again, the agency is not looking at it from that perspective. They're saying, let's look at the water resource and how do we protect that? Because that's our charge. And how do we do that the best way? And I guess the thought is the 500-foot buffer does that. Why is that better than the 100-foot currently? I don't know.
Well, I'd say we've pretty thoroughly discussed this topic. Does anybody have any thoughts on what action, if any, that we should take? Do we want to make a statement, or should we? I mean, because at the end of the day, it's in their purview to do whatever they're going to do. And I would hope that people show up to the public hearing and share their opinions one way or the other. But you can't always rely on people to do that.
This meeting will be recorded and live prior to their next discussion on it, yeah?
I would think so, right?
Can we enter our meeting recording into the, in lieu of, there's been a lot of nuance to what we've discussed on all sides.
Right.
That I don't know that we could summarize in a statement.
Right. Well, we could say something like, we agree that protecting our resources is a good idea. However, we just hope that you do the right thing, whatever that is. Yeah, well, that doesn't sound too good. Maybe they should just go and look at and see that we did in fact discuss it in depth and in the best of our ability.
This is a better resource, than I don't know. If they want to sit through listening to this whole discussion.
Yeah, well, I mean, I think we brought up some good ideas. I mean, we could.
We could just forward them the minutes.
I think that that's a good idea, because I feel like we did honestly discuss this, and I feel like we did point out both sides, that at least to our own understanding, both sides of the issue of for and against.
I'm giggling at Sue right now.
You know,
We've given her a ginormo task with that.
Yeah.
I mean, I think you had some language, Michelle. You said that in the wetlands, you should determine what those changes should be, right? So maybe you say, we understand you're changing your regulations. We agree they do need to be updated and modernized to better protect the water resources. You know, as I'm sure you know, there are a million concerns that go along with that. You know, do your home. I don't know.
Yeah, that's the part where it's difficult, is to, you know, offer them, because it is a science-based thing that I don't have a specialty in. You know, other than to say how it would affect the town.
You know, I guess, right. I guess that's my point, is that I would hope, it would be my hope that the agency as agents would use all, you know, consider how it would impact the town collectively.
And you can tell them that at that meeting, you know, right? Because you'll be having the same discussion with
Similar.
them as you are with us.
It would be much different. It will be. I can tell you that. It won't be as loose. Because I am neutral on the position. You know, I mean, I have my professional opinion, which I can share with you. But I'm going to hold that and keep that to myself right now. And just say, hey, whether it's up to the agency, they're the policymakers. I think they do need to consider, you know, the implications of the change and what that means for not just the residents of this town, but also the municipality, how it impacts operations, how it impacts staffing. So those are all concerns that I do, and I'll bring those up to them and say, hey, please consider these things in your decision making, and that'll be it. And we can only hope that they do. And I'm sure they will. You know, I mean, it's a good board. You know,
Yeah.
You know, Gary's a competent individual. You know, he's ran the meeting before. He can do it again.
Yeah.
You know, she holds a doctorate in hydrology. Ms. Chantrell, she holds the EIT. Doreen, she's a biologist. Dave Schmidt, you know, former retired fireman. So it's a good mix. It's a good commission. I think they have Don Finister. Obviously, he was from this commission, but he's over there now. So I think they have a good commission to vet this question.
Yeah. I think that sending them a copy of the meeting minutes, or I think that would be sufficient. And hopefully they'll go and watch or listen to the discussion that we've had. So that's pretty much all I have to say about it.
Okay.
If anybody has any other ideas of what to do, I would say now would be the time to share them. 'Cause I think I'm ready to move on. Any other thoughts on this topic? Okay, so that was item D. Moving on. Bylaws, discussion and possible motion. What is this? Hearing?
I don't know what happened. A little volume audio issue here, big screech.
Okay.
So we put the bylaws discussion possible. I don't think you have did you get a copy of the bylaws? Do you have that?
I do not have them in front of me.
Okay.
It's in the link on
Oh.
here. I can put it in the chat again.
I think back in, was it January or February, we had discussed putting this on the agenda for discussion. Because it was so long ago, I wasn't sure where we were with that, what we wanted to do specifically. And I forget, I want to say that it was related to something we ran across, and we, I don't know, had a snafu issue, you know, some problem. And we wanted to try to rectify that through our bylaws, and I'm not sure. Anybody recall?
Oh, man.
Okay. So maybe it was just a desire to update them. I don't know. But my suggestion is the fact that they're here, it doesn't hurt to look at them. we can keep it on the agenda for the next meeting. Everybody can review them, and if you think they ought to be updated or changed, we can suggest changes.
I think we leave it on the agenda and wait until after our POCD business is completed.
Okay.
Anybody else have any other opinions? So, okay, so let's move on to F.
I think that was kind of the same
Oh,
situation.
same, okay. Yeah, let's do the same with that. And with that, that brings us to adjournment. Do I hear a motion to adjourn?
I submit a motion to adjourn. Richard Gordon.
Thank you, Rich. Do I hear a second?
I second Nicole Davison.
Oh, thank you very much. All those in favor? Oh, wait, I have to get on. I have to do the roll call. Michelle? you wanna
Aye.
adjourn?
Yes, please.
Richard?
Aye.
Nicole?
Aye.
Okay, aye. Meeting adjourned. Time is 9:08. Thank you very much, everybody. We'll see you at our next meeting or the POCD meeting, or hopefully maybe before then. Thank you.
Thank you.
Thank you.
Good night.
Good night.
Good night.
Good night.